Hello, I'm 𝗪𝗫𝗀𝗋, founder of Starlit Contracts, where we help you to negotiate and use contracts with confidence. This video is part of our Build the Foundation in Contracts program, and our topic is caps on liability and unlimited liability. Let's look at this topic in summary to begin with, and firstly, it's very common for contract parties to want to limit their liability to the other party. It's most common for suppliers to want to cap their liability towards a customer, but in some cases, customers also want to have their liability towards a supplier capped. Now, some forms of liability cannot be capped, and what those are depends upon the law that governs the contract. But for example, it's very common that a party is not able to limit their liability for personal injury or death that they are responsible for. So how does it work in practice? Well, the main question to consider is, at what level should liability be capped? And this can vary enormously, really depending on the product or the service that you're providing or the industry that you're working in. But it's quite common when you're supplying goods that there would be a liability cap which is linked to the value of those goods. Or alternatively, if you're providing services, the same can be true, that there's a liability cap that's linked to the value of those services. Now, if you've got a long-term contract, you might be providing goods and services over a number of years, then the liability cap might be linked to the payments that are made under that contract over the course of 1 year. So is this something that you should care about? Well, from a legal contractual perspective, having a cap on liability tends to be one of the most important clauses in the entire contract, and it becomes even more important in circumstances that you don't have a consequential loss disclaimer. So consider for your contract what is being supplied, whether it's goods or services or anything else. What is the risk related to that? And is it important for you to have a cap? In most cases, I would expect the answer to be yes. There are exceptions to this. For example, for contracts which don't actually involve the supply of products and services, they might not have a cap on liability. In fact, it's rare, I've never seen one, a cap on liability in a non-disclosure agreement, or even in a memorandum of understanding. Let's look at a practical example together now. Faulty Services Supplier Limited entered into a contract with the customer. The supplier's work had severe defects that cost the customer an additional 50% of the contract price to fix. Supplier's liability is capped at 10% of the contract price, though liability for gross negligence is excluded. Gross negligence is an example of a form of liability that also cannot be capped under some governing laws, but under others it can be capped. What can go right for the customer in this situation? Well, let's say when the supplier and the customer signed the contract, they agreed that liability for gross negligence would not be capped. When the customer is able to demonstrate that the supplier has been grossly negligent, as that term was defined in the contract, that should mean that the customer is entitled to claim losses in excess of the 10% liability cap. Now, whether they're able to recover their full 50% of losses or not depends on other disclaimers in the contract, such as the consequential loss disclaimer. What could go wrong from a customer perspective? Well, let's say the contract did state that liability for gross negligence would not be capped, but the contract didn't define what gross negligence means. Well, it might be that the law which governs the contract also doesn't recognize the difference between gross negligence and simple negligence. In that situation, if the customer wanted to pursue that claim against the supplier, it might mean they need to go to court or through some other form of dispute resolution and have the uncertainty or whether the judgment would be in their favour or not. So this is going to be costly and it's going to take time, and naturally it can be somewhat stressful going through a disputed process. On that basis, it's more likely that a customer might say, on balance, I think I'm going to absorb that cost myself rather than going through the complexity and time and energy to try and seek some sort of remedy before the courts when I don't know if it will be successful or not. Now let's look at a sample clause and some key considerations. And firstly, to the clause. Supplier's liability to customer is capped at, let's say, 50% of the contract price or the average annual price of the contract, whatever you might choose, except for any liability that cannot be capped under applicable law. And then you can have other carve-outs from the cap on liability, such as in case of gross negligence, willful misconduct, and in accordance with clause whatever it might be. The first question you might have is, why is the clause capitalized when others we've looked at together are not capitalized? Well, under some governing laws, it is required that the limitations of liability and any disclaimers from that cap on liability are very prominently identified. It might be in capitals or it might be in bold lettering, for example. If you're uncertain when the law that governs your contract requires you to do something like this, then you can just retain it. In fact, having capitalized or bold caps on liability does you no harm. Next, if you're using words in your contract that don't have an established meaning under the law that governs your contract, or that are not otherwise clear, it's important to insert their definition into the contract. So that's especially important if you're using such words in your caps on liability and exclusions from liability. So for example here, gross negligence, willful misconduct. It might be that they're established under the governing law for your contract, and in other cases not. If not, insert that definition in the definition section to ensure that you're able to enforce that limitation of liability regime in the way you intended when you entered into the contract. And the clause continues, the limitations and exclusions of liability in this agreement apply whether a claim is based on a breach of contract, tort, including negligence and strict liability, or under any other legal theory. The reason for this clause is to make clear that it doesn't matter on what basis a claimant is filing their claim. Maybe it's for a breach of contract or maybe it's for negligence. In all cases, it's the intention of the parties that liability be capped in the way that's described in the contract. So to give you a practical example, it can be the case that when a claimant is filing their claim before the courts, they choose to pursue a claim that's one, based on a breach of contract, and then a parallel claim which is based on negligence. So you would want to ensure that if you are the other party, if you're the defendant in that case, that your contract with the claimant was clear that liability would be capped at the level agreed in the contract in all circumstances. I hope you found this introductory content helpful, but if you're ready for the next step to learn how to negotiate and use contracts with confidence, then check out our website starlitcontracts.com, where you can become a member to access additional content, interactive sessions, and be part of our community. I look forward to seeing you there.